Hello, Canada and arbitration fans of the United States and around the world. My name is Joe MacArthur. I'm an arbitration partner at Blake's and chair of the Vancouver International Arbitration Center. On behalf of VanIAC and my course co-chairs, arbitrator Ken Glasner, QC, and my Blake's partner, Laura Kandari, I want to welcome you to our two-part mini course, Arbitration Nose to Tail. Today is the nose, and we have an awful lot of ground to cover and not a lot of time. So we're going to do away with most of the pleasantries. Needless to say, every member of the faculty is a recognized expert as arbitration counsel and or arbitrator, and there's a link to their bios in the agenda that you have access to. And just like VanIAC, our faculty is experienced in both domestic and international arbitration. So without further ado, I'm going to pass you off to our first panel to provide an overview of arbitration, chaired by Dan Urbis of Urbis Arbitral and with Jonathan Eads of the Ministry of Attorney General of British Columbia. And if the other presenters want to turn their cameras off now, that would work out well. Dan, over to you.
Thanks a lot. Thanks, Joe and Laura and Ken for organizing this. I'm so happy to be part of this opportunity to talk to Dispute Resolution Council across the great province of BC, across Canada, the US, and many of the countries that have signed up. My co-panelist with Jonathan Eads, he'll be introducing some distinctions with domestic and international commercial arbitration, the very up-to-date BC Arbitration Act, and the equally up-to-date VanIAC rules. My role is simply to introduce two slides before we get to Jonathan's very interesting talk. But before we start, I wanted to just mention some comments by one of the chairs, Ken, that Jonathan and I shared our slide deck with, and he sort of mulled it over and he says, you know, you have two worlds colliding here. And I just want to read quickly just from an email he'd sent on the two worlds, or he called scenarios. He says, in one world, it's 9:30 the morning of a 2-week trial dealing with a corporate commercial dispute set down for 15 or 18 months previous. And as counsel, you spent the last week preparing. You're there with opposing counsel at the courthouse. You each have 6 witnesses, and the clerk advises you that there's no judge currently available. You might have to reschedule till next month, but suggests you come back at 2 p.m. At 1:45, you're informed you are in luck. A judge is available. She's an excellent judge, well known across the province. She's well versed in criminal law and constitutional law, and you're unable to confirm to your clients whether she has the significant background in corporate commercial disputes. In the other world, I think it's Ken's favorite, he says parties have chosen an arbitrator who has depth of knowledge in both the subject matter and arbitral process. Within 2 days of her appointment, the counsel receives a first communication from her inviting counsel to set up a first case conference within 3 weeks, and offers you flexible dates and time slots. She encloses a review draft agenda, invites counsel to take the initiative in agreeing to much of the process. And after the first case conference, the procedural order or the joint procedural timetable in place, the counsel will set for a 5-day trial because it takes less in arbitration and it's scheduled 5 or 6 months away. So fewer dates with the new Arbitration Act, greater efficiency with VanIAC rules. And if it goes to a full hearing, you'll get a written decision sooner than later. It sounds dreamy, and it is, and it's possible because of BC's new Arbitration Act and the VanIAC rules, which Jonathan will deal with. So just to get to slide 2, like I said, I have 2 slides that are standing between you and Jonathan Eads. It's the slides about what is arbitration. I'm going to give you some sound bites that are going to come back up repeatedly today and next week about the words that we're going to use. And if we can go to slide 2, it's the what is arbitration. And on slide 2, you would see you can see how much we've rehearsed this. The slide 2 is a mechanism, talks about the dispute resolution process. And as the slide is saying, it's a process that's private. It's agreed to by those agreeing in advance to abide by the results of someone else, an independent person who has no financial interest or incentive in the respective businesses or any predetermined mindset about the problem. Independence talks about no incentive to find for one party, and impartial means that, like a free spirit of free opinion or a mindset that's not determined by the experience. It's different from mediation, where mediation, you have a professional that helps you resolve a problem and negotiate it. It's parallel to the state system, meaning it's not litigation sitting down, it's not part of the judicial state system, and it's where you have to treat people equally and fairly. Arbitration is typically by contract, but sometimes the arbitration arises because of your membership in an association. As a lawyer, some of our law societies across Canada require us to arbitrate fee disputes, condo disputes, sports disputes. The thing is, you might not know it, but you might have agreed to arbitration simply because of the activity or the status that you have. Another distinction you should keep in mind is arbitration agreement arises before a dispute occurs, and a submission agreement is something you can enter into after a dispute. So don't be discouraged when you're listening to some of the presentations to say you already have a dispute and it's too bad you don't have an agreement to arbitrate. You can do it. It can arrive after the dispute. You can join in a parent company, a holding company, parties, executives, or even a spouse. And also the limited role of the courts, it's to assist, not interfere. And one way the courts assist in Canada is they decline to get involved if there's an arbitration clause. They'll help you appoint an arbitrator, help you assist in collecting evidence, and stay out of any involvement in interim orders, and as well as recognize and enforce the results. Next slide, please. The benefits of arbitration. Again, these are benefits that you can lose if you don't have the right rules, such as the BC Arbitration Act, or you don't have the right administrating organization like VanIAC, which has up-to-date rules, experienced staff, and many years of case management experience. So these benefits, they're like a promise, and it's up to you to miss them by making the wrong choices about venue. Choice of decision maker, that simply means you want to choose when you know what is in disagreement. Is it a legal interpretation, fair market, or book value in an accounting dispute, or a product defect in a manufacturing liability case? You can also find someone who, since they know a lot about the area, they can skip many steps that they don't need to explore because they don't need to boil the ocean to serve you the tea. Continuity and availability, this is very good, is that there's no turnstile of judges that you go to the courts and re-educate and re-explain and maybe hear your party on the other side nuance their case every time they go back to the court. This really saves time and reduces expense. Procedural flexibility, this is one of the main benefits. You get experienced counsel, experienced rules, and you get to tailor it. In arbitration, less is more. Not every procedural possibility needs to be done. You do it as necessary and not just because it's there like Mount Everest. The last couple of things is private process and confidential. Two things to keep in mind. Your boardrooms are private. Once you step out onto the street, there's nothing preventing you from sharing it. So not only is arbitration private, you can agree that it's confidential. It can be presumptively confidential. Speed and time, obviously, you have the focus of your decision maker, his or her availabilities. They sit longer days, weekends, holidays, and you can either toggle between different locations. Finality and enforceability, this is great. There's so many agreements between jurisdictions to enforce the awards. Cost, this is a big one. You can, as the prevailing party, recover your actual and legal costs, and that's a very big incentive when you're into dispute resolution. So with that short intro, I'd like to turn this over to Jonathan Eads. You are to be treated to something. Jonathan not only pleads at the Supreme Court, he handles active cases at the council level, but he actually drafted this legislation with the help of most of, if not all, the other panelists. This is a remarkable opportunity to talk to someone who not only litigates the legislation, he drafts it, and now he's going to explain its features. Take it away, Jonathan.
Well, thanks, Dan. That's very kind what you've said. And thanks, Joe, and to everyone else at VanIAC for having me here today. I recognize today we've got a wide selection of people from around the world. So I'm going to be speaking about British Columbia's arbitration statutes, but I want us to keep in mind that what I'm discussing really does apply to many of you around the world. And we probably have someone from every continent other than Antarctica on this in the webinar today. So let's talking about BC, but remember, we'll look at your own, for those who are outside jurisdiction, you want to look at your own arbitration acts if you're arbitrating in your own jurisdiction. BC has two arbitration statutes, the Arbitration Act, which we also call the Domestic Act, and the International Commercial Arbitration Act. Both of those are modern, state-of-the-art. In the International Commercial Arbitration Act was majorly updated in 2018. The Arbitration Act, the Domestic Act, was, we say updated here, but was repealed or replaced in September 2020. And both statutes, and this will be again relevant to our international audience, are based on a UN model law, the Untitled model law, which has been enacted in more than 100 jurisdictions around the world. And this particular act, the model law, was promulgated in the mid-1980s. It is being updated, and British Columbia's legislation reflects all of those modern updates. Now, and I will speak a little bit more about the International Act in a minute, but let's move to the Domestic Act. The Domestic Act applies to a wide range of disputes, largely, but not exclusively, commercial. You can actually, as Dan indicated, you can get into arbitration in other ways. There could be statutory rights of arbitration, which can direct you into the domestic legislation. I note in British Columbia that labor and family law have their own legislative regimes. The Family Arbitration Act, this is an inclusion in the Family Law Act, again, is based on this model law. Model law it's a proven template that works around the world, which makes it very, very easy for international business parties, if they're arbitrating domestically or internationally, to understand the basic framework. When does the Domestic Act apply? It applies if the parties have their places of business in British Columbia, or if in their arbitration agreement, they name BC or place in BC, Vancouver, for example, as the place of arbitration, or they provide that BC arbitration laws apply to the dispute, or it provides that the laws of British Columbia are applicable to the substance of the dispute. Or finally, if it empowers a person or entity to name the place of arbitration, who then names BC, a place in BC as the place of arbitration. The International Commercial Arbitration Act applies when commercial arbitration is international. And commercial arbitration, commercial is a very expansive open-ended term, which applies to a vast range of transactions. And arbitration is international if parties have their place of business in different states, or one of the following is located out of the state where the parties have their place of business. A substantial part of the obligations of the commercial relationship is to be formed, place of arbitration in the arbitration agreement, or place where the subject matter dispute is most closely connected. A lot of people can get confused and forget this. With British Columbia, for example, we have lots of cross-border relationships with the United States. You go 2 miles south into the United States and you've got your place of business in Blaine, Washington, and someone else in Vancouver. And an arbitration agreement, you're under the, naming Vancouver as the place of arbitration, you're under the International Act. There's guiding principles of both of these model law-based legislation. And again, very applicable to our international audience, who's people listening from outside British Columbia or outside Canada. One, party autonomy. Dan touched on this. The parties are free to design the arbitral process as they see fit, subject to mandatory minimums for procedural fairness and natural justice. That's incredible flexibility compared to the court process, where you have a one-size-fit-all model and you get pushed into it. Here, you create your process with the other side, with the arbitrator. Luckily, as we'll come to the VanIAC rules, there are some template guidelines which can really help make your arbitration move forward. Another guiding principle, parties to valid arbitration agreements should be held to their bargain. In arbitration, you can't try and jump out and litigate. You've agreed to arbitrate, you arbitrate. The arbitration tribunal should be neutral and unbiased. The arbitration tribunal is competent to determine its own jurisdiction. This is the principle that you hear about in arbitration of competence. Another guiding principle, the arbitration proceed in private without substantial intervention by the courts. And the resulting arbitration award should be readily enforceable, subject to review only for a limited and specified list of fundamental flaws, such as natural justice, procedural fairness, public order issues, etc. The new Arbitration Act in British Columbia, even for those who are outside jurisdiction, I really do recommend you read it. It's logical, it's easy to follow, and it's structured into parts which track the main steps and sequencing of an arbitration. As I mentioned, there's great harmony with the international process. And for those who are arbitrating under our legislation, one of its great disadvantages previously was the appeal process, which was cumbersome. Now, this may sound very strange for people who are listening in from the United States and other jurisdictions which do not have appeal process in arbitration. This is the British influenced world, Australia, New Zealand, South Africa, England itself will be very familiar with this appeal function. It has existed in the United Kingdom for 30, 40 years, but it's very, very constrained now and very simplified. And you can opt out of it as well. So you've got, and that leads into party autonomy under the new act. You can opt out. I just mentioned the appeal provision. You can opt out. What else can you do? You can choose your number of arbitrators. You can choose the applicable law. You can choose whether law even applies to the dispute. You can have a dispute decided on general business principles of fairness if you want. You can decide whether direct evidence would be received in oral form. That's different than civil litigation in British Columbia and many jurisdictions. The presumption in court, of course, is that is in oral form. The presumption in arbitration under the new act is just the opposite, that your direct evidence will be in writing, but you can opt out of that. You can decide whether you need to have oral hearings. You can place limits on the procedural powers of the tribunal. You can convert the arbitrator into a mediator. And you can have ad hoc arbitration, which is parties do it themselves, or you can have your arbitration administered by a body like VanIAC. And I will tell you my recommendation for the government of British Columbia is clearly to go for administered arbitration and for all arbitration in British Columbia to use VanIAC and its rules, which I'll discuss. In September 21st, September 1st, 2020, the former British Columbia International Commercial Arbitration Center became VanIAC. That was the same day the new act in British Columbia came into force. A new name, a new logo, a new website, a new statutory responsibilities to decide fee disputes between arbitrators and counsel, for example. That's a unique role that they alone have. And new rules above all. The rules were intentionally drafted to dovetail with and supplement the Arbitration Act. And these rules provide several easy to follow features to help keep the arbitration on track and help parties or counsel unfamiliar with arbitration move that process forward. And in my respectful opinion, as the person who's asked within government, shouldn't the new rules be expressly incorporated in arbitration agreements? I say a resounding yes, they should, for any domestic arbitration matter. And I'll come to VanIAC's international rules just at the end. But the advice would be the same. Why is that? Why should they? What's the advantage of these rules? What the rules do, and this really does set the stage for the rest of this conference over this Thursday and next Thursday, is they codify, as does the Act, but this is in a more particular practice basis. The very best arbitration practices are codified in these rules. And I know some people may be thinking, well, I don't need to do that. I don't need to have them codified. I know how to arbitrate. You may well do. But your client, the opposing party on the other side, your client may know how to arbitrate, but the opposing party may not know how to arbitrate. And we come up against this time and again. People who really don't know how to arbitrate and need a template to guide them forward. So that's why I strongly suggest in your domestic commercial agreements, include a reference to VanIAC administering authority and their rules, because you'll start guiding the process in the right direction right off the start. There's template standardized forms, a notice to arbitrate. There's witness statements, again, with template for content to start structuring the arbitration properly. These are all items that people are going to discuss in this seminar over the next 2 days, today and next Thursday. There is a template standardized form for requests for documents, which is a really important aspect of arbitration, which shall be discussed. There's the ability to have emergency arbitrator access before when a dispute arises immediately and an arbitrator hasn't been appointed. You can go to VanIAC, just like you go to court, and get injunctive relief prior to the appointment of the tribunal, preserving your confidentiality. Unlike a court injunction, of course, which is all in the public domain. Huge advantage. There's terrific structured conduct of proceedings provisions. Again, people will be discussing these items in the conference. They structure the initial procedural conference with the arbitrator and the other side, an absolutely critical step in arbitration. Structures the exchange of materials, the witness statement requirements, and production of documents. And this last one, to me, is perhaps the most important for me in advising parties in government. When ministry clients come to me, they say, Jonathan, why these rules? And I say, because of this, number 4. There's an expedited process for disputes under $250,000. It's a default provision. You can change it out, but its presumption is that it's going to be documents only, and there's an arbitrator fixed fee. There's time-limited cross-examination. It can be agreed or ordered, and there's no appeal, absent party agreement to the contrary. Why is this so important? Because if you can get this, I find now to litigate a dispute of $250,000 is extremely difficult. There's so much process that gets put into it. You can't justify a 2-week court hearing for a $250,000 dispute in Canada anymore, in my opinion. But if you've got this express process, and of course, when you're contracting with another side, you don't know what the value of the dispute is going to be necessarily. You could well end up with one of these relatively low-grade disputes under $250,000. You don't want to throw too much process at it because it doesn't bear it. And VanIAC's rules streamline that process and push you into an expedited process, which is just terrific. So our contact details are there, but there's a couple of other points that are not on the slides, which I really do think are important to add. One is what I've been speaking about VanIAC and their domestic rules. VanIAC right now is in the process of preparing new international commercial arbitration rules. And I've spoken with Joe MacArthur, and the group of people they have put together to prepare those rules are top caliber people, arbitrators, Arbitration Council, with a wealth of experience, both in domestic and primarily, of course, here, international commercial arbitration. I understand those rules are going to be coming out in the fall. I really look forward to seeing them. And if they meet this, if they come close to the standard of the domestic rules, and I know they will, they'll be at least as good, they're going to be simply outstanding. And then I want to say something about Vancouver, particularly for the international people listening here. Vancouver, I've had the very good fortune to arbitrate in places like New York and Washington, Geneva and Paris, and Vancouver as well. I can tell you that Vancouver is one of my favorite places in the world to arbitrate. It's a wonderful, easy city to access for airports, hotels, the facilities. You've got VanIAC services to assist your arbitration move forward. Remember, of course, in arbitration, you can have the difference. There's a difference between the hearing, where you have your hearing, and your place of arbitration. You can have your place of arbitration. You can decide that it's New York City. That's the legal situs of the arbitration. Yet you can decide, you've got the flexibility in arbitration to have your arbitration in Vancouver. And I really can recommend Vancouver for people who haven't had the pleasure of coming out to the West Coast of Canada. It's a wonderful place to arbitrate. VanIAC is there to help.
Jonathan, before you sign off, there's
Sure.
a lot of interest in the chat about the slides, and the slide deck that we've prepared is for the time allotted, but you do have a really excellent slide deck that's much more extensive. Would you agree to share it for free through the VanIAC, the other robust slide that you've given on prior occasions?
Yeah, I would just have to check to make sure it's up to date, Dan, because I think that deck that I prepared was last summer. But I'm happy to, I will make that available to VanIAC, and VanIAC can share it to anyone who's interested.
So please don't, any of the 500 people registered, please don't email Jonathan directly, but the VanIAC will post them with Jonathan's approval.
Exactly. Thanks, Dan.
We're done, and we're going to hand over to the next panel.
Great. Thank you, Dan and Jonathan. That was an excellent introduction to commercial arbitration. Before we move on to our discussion of how to commence an arbitration, I just want to note for all the attendees that if you have questions, you can put them into the Q&A function at the bottom or the chat function. And at the end of the 3 panels, we will stick around and try and answer some of those questions. So with that, I'm very pleased to introduce our 2 panelists very briefly. Henry Alvarez is an independent neutral at Vancouver Arbitration Chambers, and I think it's fair to say he's one of Canada's most well-regarded arbitrators internationally in the world of international arbitration. And Tracy Cohen is one of the leading commercial dispute resolution lawyers in Canada, and she's also the chair of Fasken Martineau's National Arbitration Steering Committee, so they're very well placed to provide you with an introduction to this topic. As we move through the topic, Henry's going to focus on international arbitration and Tracy will focus on domestic arbitration, as there are differences and those differences matter. So Henry, could you start by touching on the difference between international and domestic arbitration and why that difference matters when you're commencing arbitration?
Of course. Thanks, Laura. Typically, you'll commence an arbitration by way of a request for arbitration or a notice of arbitration. That's your first contact with the tribunal, and it's a critical document. And we're going to talk a bit about that in this presentation. I preface my comments by saying that much of what we will say and what other speakers will say depends tremendously on your arbitration agreement or clause. And when you're going to commence an arbitration, whether international or domestic, you want to read that clause and understand what it's got you into. And hopefully, the person drafting the agreement will have thought it through and understood some of the issues that we're going to talk about and tried to ensure that they're covered off and that you have a good, useful regime. Before you trigger an arbitration, again, whether national or international, and be good to know the difference, make sure you understand what your clause provides for and what you're heading into. Now, I think there's a critical distinction between whether you're commencing an international or a domestic or national arbitration. It's important because it creates different regimes. The international regime, as Jonathan has told us, is focused on the UNTITLE model law. It's an effective, well-oiled, best practices machinery, and it ensures an effective process from nose to tail. It's adapted to international commercial disputes, which means limited court intervention, supervision, assisted enforcement, limited court review, and affects practically how the arbitration will be conducted. Because usually in international arbitration, or not, if not usually very often, you have parties from different legal regimes. So the rules that you're getting yourself into are very important. Domestic arbitration, on the other hand, is more closely tied to the jurisdiction because it applies more broadly. The Arbitration Act, for example, in British Columbia applies to all arbitration that is not international and commercial. And therefore, there's a reason to have greater court supervision, why there is still a retained function of appeal. We can talk about how limited or unlimited it is. It's still not entirely as simple as some of us would like, but you have to bear in mind that if you commence a domestic arbitration in British Columbia, or very likely elsewhere, you may have an appeal provision, which may give rise to unexpected or unwanted litigation after you have your arbitral award. Now, you may think it's easy. You know what an international commercial arbitration is and a domestic arbitration is. That's not obvious, especially in this world where we have businesses become so internationalized and we do many things online. And that will be a factor we'll talk about later. Now, in the world of virtual hearings, don't forget, it still matters whether you have a domestic or an international arbitration. We still see cases where, for example, parties will choose, they'll put in their arbitration clause, arbitration in Vancouver pursuant to the Arbitration Act, the domestic statute, when really the arbitration is not domestic. It's between a Canadian and a US party, or it's between two Canadian parties with respect to a mining project in the United States or somewhere more exotic. Once that issue arises in an arbitration, it can cause considerable difficulty. Arbitrators will want to know what their jurisdiction is. Is this an international or domestic arbitration? What rules will apply? And more importantly, will it result in an enforceable award? So you really do need to understand whether you've got an international or domestic arbitration before you pull the trigger. Jonathan set out some of the characteristics or some of the defining conditions of an international arbitration, and they're broad and they're open-ended. I mean, they can be as simple as the place of arbitration is outside of the place where the parties have their place of business. So that's the first step. But then the second one is commercial. And again, you'll think commercial is easy to identify. Well, not so. Those of you who are familiar with the recent Supreme Court of Canada decision in the Heller versus Uber case will see that it's not obvious. That was a case which purported to be a license agreement, which specifically said it did not create an employment relationship, but rather a direct business relationship. Nevertheless, the Supreme Court found that it was not commercial in nature, and therefore the domestic legislation of Ontario applied. Now, at the end of the day, the rationale for the court's decision may not have made a big difference for the reasons that they stated, but it shows you can't automatically assume what's written in your contract or your clause will apply. And I think you need to understand that. And even then, you may say, oh, well, an employment or a consumer dispute is easy to identify. I'll know whether I'm under one act or the other. Not so. There's lots of room for debate over whether something's an employment dispute, for example, or whether it's a dispute that arises from a commercial relationship, which is the language used in the National Commercial Arbitration Act. So you need to think about carefully and before you start. Otherwise, you may cause confusion. The other point I wanted to make quickly, Laura, is bear in mind that the arbitration will be governed by the law at the seat of the arbitration, which means that even though you may have chosen British Columbia law as applicable to the statute, if you seat your arbitration or name a place of arbitration in the United States or the United Kingdom or elsewhere, those local rules are going to govern the overall conduct of your arbitration. It's there, for example, that parties can apply to set aside an award. The regime for costs may be completely different. In England, for example, under their Arbitration Act, one of the articles of their act invalidates provisions in an arbitration agreement that allocates costs between the parties before the commencement of the arbitration. So you can't agree that each party will bear their own costs in your arbitration clause in advance of the arbitration. Confidentiality, somebody noted earlier. Confidentiality will change from jurisdiction to jurisdiction. And importantly, as I think we'll discuss later, under the rules that apply to your arbitration. So there in a nutshell is why I think it's important to distinguish between the two, Laura.
Thanks, Henry. That's really helpful. And I think this concept of seat is something that's a bit foreign to litigators who aren't familiar with arbitration. So I'm happy you touched on that. Tracy, did you have anything you wanted to add on this first topic?
Thank you very much, Laura, and thank you for the introduction. It's great to be here today and great to see so many experienced people joining us. So I think the only thing to add to that, and I think it's definitely wise thoughts, you really do need to look at the provision, both the arbitration agreement that gives rise to the right to arbitrate, and then also the applicable act and rules. And I think that really does govern. And I agree, the seat of arbitration is a huge issue, and why when you're dealing in a domestic arbitration, it's generally much smoother because you know the rules, the procedural rules of your jurisdiction usually. And when you end up having a seat of arbitration outside of your jurisdiction, you really need to think about those in advance, particularly with respect to things like costs or what happens if you need interim relief, interim measures relief, and when that's going to be available. And confidentiality, particularly in jurisdictions like ours, where there is a potential right of appeal, because if there is an appeal, even though the parties may have agreed to a confidential process, there are circumstances in which where there's appeal rights, those confidentiality provisions become essentially worthless because all of the materials become public once the appeal is commenced. So I think those are all important things to keep in mind for sure.
Thanks, Tracy. I think that answers one of the questions too we've had in the Q&A about confidentiality when there's an appeal. So that's helpful. Going back to the agreement, could you talk a little bit about how you know it's time to commence an arbitration? Oftentimes we see these complicated provisions that have negotiation and mediation. How do we know when it's ready for arbitration?
I think it's really important to make sure that there are different rules provide different requirements for commencing arbitration. And it's particularly important in circumstances where you might be dealing with a limitation issue, because if you don't commence the arbitration within the limitation period, you can essentially be barred from bringing forward the claim. And in our domestic rules, it's very clear how to commence an arbitration by way with the VanIAC rules by filing a notice to arbitrate. And it provides a very helpful framework for what you need to do in order to commence the arbitration. You need to serve the notice to arbitrate, and you need to pay the fee. And the arbitration does not commence until both of those steps have been satisfied. So particularly in circumstances where you're running up against a limitation period, if you don't do that, you're going to find yourself in difficulty. Other rules don't require anything quite that formalistic, and you may be able to commence an arbitration just by sending notice effectively by way of a letter or otherwise to opposing party and making it clear that you're unequivocally referring the matter to arbitration. So you need to make sure that you're doing whatever is required under the applicable rules and statutes in order to commence that arbitration, so you don't bar yourself from being able to do so. You've raised an interesting question, Laura, because I think when you have step clauses, that becomes more complicated. And particularly in circumstances where you have a stepped clause that starts with negotiation and then moves to mediation and then moves to arbitration, often it becomes quite unclear as to whether or not you've satisfied those steps. And if in particular a negotiation imports an obligation, for example, to use best efforts to negotiate, best efforts is a very high standard. And if you don't satisfy that standard, if the parties just go through a rote exercise of, okay, let's have our phone call, I phoned you, oh, you're not prepared to pay the full amount, goodbye. That might not satisfy the requirement to negotiate in good faith using best efforts. And if you don't satisfy that process and you then commence an arbitration, it becomes questionable whether or not the arbitration has been properly commenced and whether or not the arbitrator has appropriate jurisdiction. And that can be a real problem if you run into a limitation issue as well. The other point to note is that arbitration agreements themselves sometimes will impose different time limits or obligations to commence proceedings within. And if you don't follow those, even if you are within a statutory limitation period, you may run afoul of those party imposed obligations and then be without a remedy. So I'll pause there to let Henry jump in, because I'm sure he has a great wealth of experience in this area, and turn it over to Henry.
Thanks, Tracy. You made a very good point about the time limits. Let's use a different, more neutral term, the time limits in an arbitration agreement or clause. Those bind an arbitrator and they bind the parties contractually. It's not a statutory limitation period, and it's quite different, but they bind the parties and they bind the tribunal. So if you're drafting clauses, make sure that you put, if you feel you have to put in a time limit, that you put a realistic one in, because otherwise, if you miss your time limit, an arbitral tribunal, usually his or her hands are tied. There's not much they can do, and that can be a real problem. At the very least, it will give rise to the antithesis of arbitration, litigation, at the outset of your intended arbitration process. The other point is step clauses. Takes me back to the drafting of the clause in the first place. If the steps are not identified by, for example, putting in time limits, so you can say the parties shall attempt to negotiate. If they can't negotiate a solution within 20 days, then you go to the next step. Unless you do that, you very often will run into problems, because while parties are happy up front before an arbitration commences, once it does, things will change drastically, and one party will be reluctant, usually the respondent, and they will use whatever is available to delay or to make the process more onerous. So make sure that you try to comply with these clauses, because they are enforced by courts around the world. And they may even affect the enforceability of your award at the end of the day, not just the commencement and the procedure of the arbitration, but enforcement at the end of the day. So it can be difficult, but I think as counsel, you want to make every effort to, if you can't actually get the other party to agree to meet, to negotiate, or to go to mediation, you make every effort to create a paper trail that shows that you have invoked all the conditions or try to satisfy the conditions in order that you'll be able to argue before the tribunal or a court that everything possible was done, and at the end of the day, it was not feasible due to the other party's recalcitrance.
Some good cautions about stepped arbitration clauses. And I always remind parties, if they want to include that you can always negotiate regardless of what your clause says. So I try usually to talk parties out of them, but if they're there, you do have to pay careful attention to them. Henry.
That's a really good point.
Henry, what other information should you pay attention to in the arbitration agreement when you're commencing an arbitration? We've talked a little bit about timelines. What if there are references to institutional rules? Are there other things that we should be looking out for at the time of commencement?
Well, there's a lot to be said here. First and foremost is the seat. Make sure you understand the seat or the place of arbitration. We'll talk in a minute about rules, and there are rules and rules. Generally speaking, particularly in international arbitration, rules are heavily used and I think are critical. They're a great advantage, again, particularly in the international context, where institutions have spent a lot of time developing how best to offer an arbitration that will be efficient, as cost effective as possible, and provide a final award. There's a temptation, I think, sometimes to want to avoid the cost of an institution. I think it's wrong-headed thinking in almost all cases. Ad hoc arbitration may be your only choice at the end of the day, but if you can possibly avoid it and find institutional rules that are helpful, you should use them. They simplify the process, they make it more efficient, and at the end of the day are probably not more expensive than proceeding on an ad hoc basis, because you will get your tribunal spending an awful lot of time, and you will spend a lot of time trying to work out what the details, what the procedure will be, and you'll have disputes over it. Whereas if you had institutional rules, which do preserve a fair amount of flexibility, you're going to save a lot of time and therefore money and effort by using the rules. In the international context particularly, you want to think about many other issues, a number of which are required by the rules that you choose. And I think we'll get to talk a little bit about different rules in a minute, but at a minimum, you're going to want to think about the language of the arbitration if you're not in a domestic English language arbitration. Language both for the proceedings and documents that are used. You often see these issues come up. You will want to, and I think we put this off a bit, but you want to bear in mind that you're going to have to provide a certain number of copies required by the rules, and you're going to have to pay a fee. So you want to think about all of those. Very helpfully, most institutional rules will set out the required minimum. Now, you may well want to add more than that, and we'll talk about that in a little minute, I think, about what you want to draft in an arbitration clause. But those are the minimum. You also want to, for example, the critical thing is you'll want to explain the relief sought in your notice of arbitration. Again, rules such as the ICC require you to do that because that's the basis on which the tribunal will be remunerated and the basis on which the ICC charges its administrative fee. Those are just a few details. You want to read your rules carefully. And if not, and even if you don't have applicable institutional rules, a good suggestion would be to read a set of institutional rules because it will give you an outline of what is likely necessary and at the very least very helpful.
But you raise a good point, Henry, too, I think about for people that are new to arbitration, having an institution is very valuable because they do have staff that will help you. And if you don't have anyone else you can call with your questions, often staff can kind of guide you procedurally a little bit.
Absolutely.
Tracy, is there anything else you want to add in the domestic context or any additional points on that topic?
I think what I would add is maybe more in the international context, but related to domestic, which is that the various institutions provide a great degree of variability in terms of the services that they provide. And I think VanIAC is doing a great job sort of reinventing itself in that regard and providing really great service in administering arbitrations. And I think it just makes the process run more smoothly. And it eliminates some of the awkwardness of having to deal with an arbitrator directly about things like fees. And I think that it really helps with not only the perception of independence and impartiality, but it just helps the process. So you don't have to run into those kind of administrative issues directly with the arbitrator. And I assume it greatly helps the arbitrators. I'm speaking more from a counsel perspective. But I think the other thing is, institutions also can provide a way of gently approaching an arbitrator if there are issues with respect to timing of things, and that can be really helpful too. So if, for example, some institutions are very much on top of arbitrators in terms of when they will have to issue their award, and we'll follow up with them and make sure that the timeline is met. And if it isn't, that at least the parties have an indication of when they're going to receive their awards. So I think as counsel, you want to know sort of what level of involvement does an institution have. And sometimes you're paying for additional services that you might not want. And that's why some institutions can be quite a bit more expensive than others because they'll provide even greater oversight by making sure that the arbitrator actually substantively answers all the questions that have been posed to the arbitrator, for example. And you might not need that, and you might not want to pay for that. So I think it's important that you give some consideration to what is the institution actually doing and providing. And I think, as I said, I think VanIAC in terms of domestic arbitration is providing a very valuable service. And I totally agree that the rules, having an ad hoc arbitration can be very difficult if you have a party that doesn't want to participate, and you have to then negotiate about everything and reinvent the wheel each time. These rules that have been implemented by VanIAC have been very well thought out and have a lot of experienced people who have helped develop them. And so they do provide a very good framework for proceeding through an arbitration and not having to have all of those debates about the process, and just have a more smooth and effective process as a result.
Laura, if I could, I should add that the Vancouver Centre and others have model notices of arbitration. And it's worth looking at those. I think that's very helpful guidance, particularly for inexperienced parties. The only other thing I wanted to mention is that some rules, such as the Vancouver Centre and others, provide for arbitral appeals. That is to say, appeals from an arbitral award to another arbitral tribunal. Now, in some cases, you may find that very helpful and very important. If you have a bet the company case, and you're worried that the tribunal might get it wrong on the law, then there's the opportunity to have an appeal procedure. I'm of two minds as to the utility or the desirability of that, but in some cases it can be helpful. You want to think about that up front, and if that is an issue, consider how and if you're going to say anything about it in your notice of arbitration.
That's a good point, Henry. And, you know, particularly if you're concerned about confidentiality, the VanIAC rules now, you could agree to that if there will be appeals, they will be to the VanIAC appeal tribunal and sort of oust external appeals. Still some opportunity for a set-aside application if there's a procedural fairness concern, but you might minimize the opportunity to go to court. So we've touched a little bit on notices of arbitration, and now just moving to putting pen to paper. Tracy, is there something analogous to court forms? Do we have to use these model forms? What should be included in the notice of arbitration when we sit down to actually start preparing it?
As Henry mentioned, I think that the form that is attached as a schedule to the VanIAC rules is very good template, and I've used their templates over time. I find them very useful. I think one thing I note the time, and I think one really important thing that we haven't yet touched on in terms of commencing arbitration is appointing the arbitrator or arbitrators. And to me, that is one of the most beneficial things about the arbitration process is being able to select an arbitrator who has some expertise in the area in which the dispute relates. And so my experience has been, I can't think of an occasion where I haven't been able to reach agreement with opposing counsel on the appointment of an arbitrator. And typically domestically, you're choosing one arbitrator as opposed to a panel. And I think the parties really do understand the benefit of reaching an agreement on the selection of an arbitrator for that reason. And the benefit of including some detail in a notice to arbitrate about the nature of the dispute and the important factual elements of it and the type of arbitrator or expertise that would be required is really important, because if you are not able to reach agreement, that is what whatever the appointing center, or if it ends up being the court, will look to as a guide in determining who to appoint as arbitrator. So I think it will help form the skill set that they're looking for in appointment of an arbitrator. And just while we're talking about that, the other sort of thing to touch on is arbitration clauses that inherently create difficulties. I've seen numerous arbitration clauses where parties in advance will attempt to select the arbitrators. And that can be really problematic, because if you say we will agree to arbitrate with these 3 people, and those 3 people end up not being available, then you have to make sure that you provide for an alternate process. Because if you don't, then it can just create further difficulty instead of trying to streamline the process. But as I say, I can't think of an occasion where I haven't been able to reach agreement with counsel. The one thing I would be interested in hearing Henry's thoughts on is the difference between appointing counsel in the domestic context versus the international context, because it's very different from my experience. And you certainly wouldn't, in a domestic context, want to be calling up the arbitrator and asking their experience with contract disputes and how many contract disputes they've arbitrated and whatnot, or having any kind of discussions. In the international context, it seems to be more common, where you have party appointed arbitrators, to have some sort of selection process where you actually review and maybe have some discussions with that arbitrator in advance of the hearing.
I'll answer your first question quickly, Tracy, because there's an awful lot to say about the form of the arbitration, notice of arbitration or request for arbitration. Yes, but it's quite well, I won't say regulated, but there are lots of guidelines set out either by institutions or others as to what is permissible in terms of discussions with arbitrators in order to determine A, their availability, which is important, and B, their general experience. The International Bar Association rules is a set of very helpful rules on the contact with arbitrators and the procedure, the rules of evidence and procedure in an international arbitration. So if you get involved in an international arbitration, have a look at those. But yes, it is accepted, and parties will often agree to do joint discussions with a potential arbitrator. But it has limits, and there are lots of guidelines out there. I wanted to say a little bit about the Notice of Arbitration. I think this is a critical document. There is no standard form. What you will find in rules is a minimum. Bear in mind that the Notice of Arbitration is not pleadings in court. This is your opportunity to say a lot more about the case. It's the first document a tribunal or an arbitrator will see, and will be very important in the early stages of the arbitration. That's what the tribunal is going to look to when they develop their procedural order, to decide exactly what the procedure in the arbitration will be. It's a critical opportunity for claimants to put the right tone and to give the tribunal useful information up front. And it's quite common, and in fact is disappointing for a tribunal, if the key documents are not attached to the request for arbitration, because it's going to take some time before you set out what your procedure will be and fuller pleadings. And I say pleadings, I use the word very loosely. In arbitration, it's more of a narrative. You're not simply pleading points of law. And this is your opportunity to set out the facts, set out the narrative, and set the whole tone for the arbitration. And you can do all sorts of interesting things. You need to think about your strategy up front. I've had a case where I received a request for arbitration together with 200 binders of information, of evidence that the party wanted to call. And that put the respondent in a difficult position, because under those rules, they had a time limit within which to respond to the request for arbitration. So that will have to set the whole tone for the arbitration. And of course, the tribunal will have to deal with that. But there is a lot to be done there. One other point I really wanted to make is, when you put out your notice of arbitration, think carefully about who the parties to the arbitration are. There may be non-signatories to your contract which are legitimate, or you may think necessary parties to the arbitration, I think you want to start that debate up front and name additional parties in your notice of arbitration. It's going to be much more difficult once your arbitration is underway. So make sure you think about that. It's a critical document. You can't overthink it.
Thank you, Henry. Thank you, Tracy, both for all those excellent points. I'm sure we could spend a lot more time talking about all of these considerations in commencing an arbitration. With that, I'm going to turn it over to Rob Dean and his panel, who are going to talk about the first procedural conference. Thanks again, Henry and Tracy.
Thank you.
Well, great. Thanks very much, Laura. And there's Angus and there's Murray. Let me just briefly introduce who you see on your screen. I'm Rob Dean from Borden Ladner Gervais in Vancouver. I'm going to moderate this panel concerning the first procedural conference. And I'm joined by Murray Clemens from Nathanson, Schachter and Thompson, and my old partner, Angus Gunn, who is now a partner at Eford Partners in Vancouver. Both Murray and Angus are very experienced in the arbitral process, both as counsel and as arbitrator. And we're going to discuss various ways in which to make the most optimal use of the first procedural conference with the tribunal. Now, just briefly to set the stage, Rule 16 of the new VanIAC rules requires that first procedural conference to be held within 10 days after the appointment of the tribunal. So it's very early, it's very at the head of the proceeding. And now, while the timelines may vary, this idea of having a very early initial procedural conference with the arbitrator or the tribunal is common to rules around the world. The purpose is to develop a procedure that fits that particular proceeding, to recognize that one of the virtues of arbitration is the ability to do different things depending on the differences in the particular case. So the overarching question of that first procedural conference is to answer that question. What's the most efficient and effective way to resolve this particular and in many ways unique dispute? Now, at that point, the parties in the tribunal will only have in hand the notice to arbitrate. And Henry spoke about that just before the earlier session concluded. And often I get parties who have the notice to arbitrate in hand and they want to defer the initial procedural conference until there's responsive pleadings, until other things have occurred. The idea of having an initial procedural conference early on when the tribunal may only have in hand and likely will only have in hand the notice to arbitrate isn't, in my view, a defect in the process or something to be overcome. It reflects the primary purpose, the very purpose of that first procedural conference, to fix the procedure before we get too far down the road. Jerry Gekas years ago wrote an article on the first procedural conference. It was published in The Advocate here in British Columbia, and it was about how to make the best use of the first procedural conference. And although the rules have changed and some practices have developed, the wisdom in Jerry's article hasn't changed. It's still of significant value, significant use, and we commend that to everyone. Now, turning to the panel, and I guess the first question I think is for you, Murray. Having in mind the purpose of that conference, what can the arbitrator do in advance to give that first procedural conference the best chance of success?
Thank you, Rob. The occurrence of a procedural meeting 10 days after appointment, as you say, limits the amount of information that you have. You will at least have the notice of arbitration, the agreement in which is subject to the arbitration, including, or as an additional document, the arbitration or agreement to arbitrate, arbitration clause or the agreement to arbitrate. And you should review those documents carefully to determine what jurisdiction the arbitration is commenced in, whether there are rules agreed to by the parties as part of their submission to agreement, submission to arbitration, or in the arbitration clause. what relief is sought and how that relief on a preliminary view tracks the jurisdiction that is allocated to the arbitrator, and whether jurisdictional issues arise from your first review, and then consider what topics should be suggested to the parties for the initial conference, procedural conference, and inviting counsel to add whatever topics they wish to have on the agenda. Some of them may be appropriate to deal with at that first meeting. Some of them may be premature, but it's very helpful to identify those future topics for subsequent procedural meetings, and give guidance to the parties in terms of thinking about the procedural steps that can be directed or agreed to address those issues and effect a coherent and procedurally fair and efficient hearing process.
And is it your practice, Murray, to generally circulate an agenda raising the points that you think the parties ought to come be prepared to address?
Yes, my first invitation to a first procedural conference usually includes a proposed agenda, which I will compose from my initial analysis. And here I'd like to, and it's something that I'd forgotten about until I was preparing for this seminar, but the BC-ICAC has had on their website, and I don't think it's on the VanIAC website, but the BC-ICAC website is still live, a lengthy list of topics for procedural meetings. It's attached to the materials, I think, that are available to all of the people attending in this meeting. And I recommend that arbitrators look at that to see what items on the menu are appropriate for the dispute in question to help guide your proposed first agenda. And counsel should also look at that document. The document that's attached to the materials has the link to the document on the BC-ICAC site, and it's still live. I've used it recently. I've updated the one that's attached to the materials to reflect the current statutory references in respect of the new act put in place in 2020. Thanks.
And Angus, from your perspective, and recognizing that this conference is happening very early in the process, how can counsel best prepare, I guess, themselves and their clients for that first procedural conference?
Yeah, I wrote down 4 points on that, Rob. The first one is perhaps obvious, which is to take it seriously. This is not a meet and greet. This is a watershed moment. Even though it's happening very early in the process, it is a watershed moment in the arbitration. And so counsel should come into it and prepare for it with that mentality, in my view. A binding order will normally conclude the pre-hearing conference process. And as you said, Rob, that document is going to govern just about everything else that happens in the proceeding. So I view, from an arbitrator perspective, the pre-hearing conference is a critical stage of the process. And I think counsel that go in with a more casual approach, I think are losing an opportunity to influence the process. The second thing I made a note of is the importance of coming to grips, and this is perhaps a related point, the importance of coming to grips with the need as counsel to come to grips with your case early. Those that come to arbitration from a litigation tradition may be more accustomed to being able to kick that can down the road, just, you know, let the litigation unfold and see what happens, and then perhaps invest the heavy lifting later on in the process. In my view, arbitration does not allow that, or at least if you take that approach, you are again giving up opportunities that you ought not to. So this includes everything from how are you going to prove your case? What are the elements of your case? How are you going to prove them? What are the witnesses you're going to need to be calling? What are the documents you're going to need to be obtaining? How many of those do you have? How many of those are you going to have to get? What are the procedures by which you're going to go about doing that? This is all stuff that you have to think through early and establish the process by which you're going to go about that. A related point is one of client relations, because again, for those from the litigation universe, there may be an expectation on the client end that the expense of litigation will sort of come later in the piece as trial approaches, for example. I think a client should be prepared for the fact that arbitration requires an earlier investment of effort. The human resources, the human component at the client's end, finding documents, finding witnesses, locating people, and so forth, and the financial impact of the arbitration can be felt sooner than it would be in the litigation process. So I think counsel can serve the first conference by preparing their own client in that way. The third thing I've written down is to confer with counsel. Obviously, these are adversarial proceedings, but to the extent to which counsel can agree on the things that ought to be put on the table at the pre-hearing conference, it serves the process and it serves the arbitrator. And so I would encourage all counsel to reach out to their counsel opposite and see how much common ground there is in advance of the conference itself. And then the last thing I wrote down here, and again, this was alluded to by Henry a few moments ago, I think counsel would do well to anticipate what the challenges are going to be as the arbitration unfolds. Are there going to be jurisdictional issues that need to be wrestled with? Are there other proceedings that need to be consolidated? Are there other parties that haven't been named that need to be? These are all things that can be tackled in an orderly way if they're raised early on, and a process can be devised to work through them. If those cans are kicked down the road, then it's going to have some adverse impact on the process, no matter how you slice it. And so the sooner that those are thought through and aerated for resolution, the better. So those are my 4 points on what counsel can do to prepare, Rob.
Rob, if I could just go back to the first meeting. The new act no longer prescribes rules governing the arbitration as was done in Section 22 of the previous act. And as a result, the VanIAC rules are not by a statute applicable to the arbitration. And so one of the important first meeting agenda items is the choice of rules, whether they be the VanIAC rules, IDRC or some other institution, or ad hoc rules developed by the parties with the assistance of the arbitrator. That issue must be addressed at a very early stage so that well, for one reason, the parties are most cooperative at the first meeting, and getting agreement on such a fundamental term as what rules will govern is easiest accomplished at that first meeting. You should also confirm the governing statute so that you can make sure that the parties have agreed on that jurisdictional basis, and give the parties a heads up that if they can identify or consider for future communication any anticipated jurisdictional issues, because those should be dealt with right from the outset and either framed as a question to be determined or if agreement can be reached, agreement confirmed in writing that jurisdiction is confirmed with respect to the specific issue for which there might be some doubt. So this first meeting it should be used to try and tie down a number of the moving pieces so that you can have a ordered and smooth performance of the procedural steps leading to the hearing.
Well, just to pick up on that point, Murray, I mean, and there are a lot of moving pieces in any case. And once you've selected the rules, VanIAC or otherwise, which apply, the rules, of course, take care of a lot of the default procedures, that the direct evidence will be in the form of written witness statements, oral and documentary discovery procedures that we're used to in litigation don't apply or should not generally apply. And that in the case of the VanIAC rules, requests for documents are usually best left until after an initial round of pleading. So the steps are laid out in the rules, but like the VanIAC rules, a lot of rules don't set necessarily timelines for those steps to occur. That's where I think that the best and one of the most significant uses of the procedural conference comes into play. And how do you set that workable schedule right at the outset? And Murray, I'll put this question to you. Do you find it more effective to plan forward and the hearing will be at the end of those steps? Or my personal preference is to set the hearing date, get that locked down and work backwards. What's your practice?
It's like yours. I'd like to have the parties' view as to when they would like to have the evidentiary hearing. That will then allow counsel and myself to contemplate available time, and that will help decide what issues, or sorry, what processes are suitable and how they can be ordered in terms of time, not only time on the schedule, but time spent in the preparation of the various steps. And so it's working back is, I think, the most effective and efficient process. But before you do that, you're going to have some of those at-large discussions about how the parties intend to proceed towards the hearing. And if it's going to be all in writing, then the date can be earlier rather than later. And so it's a combination of the two, but I find that focusing the parties on an agreed hearing date also assists everyone in fixing a process that will suit that timeline, while at the same time providing the parties with a sufficient opportunity to prepare and discover the case that they have to meet.
I guess what's your view on that? What's your experience?
Yeah, I think the tradition is generally to work backwards from the hearing date. I think that's a good discipline, and it does kind of hold everyone's feet to the fire. So I think it's a good practice. I think my only caution is that one should pick, as Murray says, a hearing date that's going to stick. I think sometimes parties underestimate the amount of work it's going to take to get from A to Z. And so my only sort of asterisk to that would be make sure that you are working on a reasonable timeline that actually addresses what needs to be done. Again, this goes back to the importance of front loading the thinking. How can you determine what an appropriate hearing date is if you don't know what's going to have to be done before you get there? And so these are really all interconnected. And I also think you should build in a certain margin of error, because almost every arbitration raises issues that nobody anticipated, and those take time to sort out. So while one always wants to get to the hearing as quickly as possible, one should ensure that in setting a date and working backwards from it, you've chosen a date that's actually likely to stick.
I guess one point that you touched on earlier was the importance of client expectations and managing those expectations. And we often hear, mostly from arbitrators, that it's useful for a client representative to attend that first procedural conference. Counsel, there may be a divide in the counsel versus arbitrator bar about that, but do you have a view on that?
I like it. I don't know that it's appropriate in every instance, but particularly where you have clients that may not be experienced with the arbitral process, I think it's an opportunity to introduce them to the process, to the participants, counsel, arbitrator, so forth, and just orient them to how this is going to go. So I think it's a valuable opportunity to inform clients that may not have had that much exposure to the process. It also, of course, lets clients see the arbitrator, see opposing counsel, and get a grasp on what's going to happen. In the era of Zoom hearings, adding a client as a sort of observer is pain-free and cost-free, and so I encourage it, but I don't think it's essential. I think in practice it may happen less often than it does happen. But I always would encourage the parties to think about it. And on the agenda that I circulate before the pre-hearing conference, that's one of the agenda items: is do we want client participation? So I'm a fan of it. It's not required. Mostly it's about the nuts and bolts of the process, and so I don't think client presence is essential, but I think it's valuable.
Rob, there's a question just been posted by John Orr. He says, how do you deal with situations where counsel for one party is ill-prepared or uncooperative at the first procedural conference? Having clients sitting in a position to observe what's going on might regulate that lack of preparation and lack of cooperation. I find that the first procedural meeting is an important time because it is, I think, where the counsel and the clients are on best behavior and want to make an impression of cooperation, comprehension of the facts and issues, and with a goal of finding a resolution. And you can achieve, I think, the most in terms of finding common ground with respect to procedural steps at that meeting, because everybody wants to be shown to be all in on making this work. And so having a client there, I think, really underscores that and also enables the arbitrator to manage a coherent, fair, and effective procedural guideline.
Well, and one question I'm going to put to both of you, having participated in so many of these initial procedural conferences and having seen the good, bad, and the ugly, what's the one pitfall, more than one pitfall, that you wish counsel and arbitrators would avoid when dealing with that first procedural conference? And I guess maybe I can put that to you first.
All right. Well, I think my number one don't do this would be, don't march into the conference with your standard form pre-hearing conference template for the procedural order and ask the arbitrator to sign it. It may well be that that's going to be what comes out of it, but I think it's much better if you take a custom bespoke approach to every arbitration. No two arbitrations are the same. Maybe 75% of the procedural order will resemble what it does in every other matter, but there's going to be that 25% that's critical. And I think if you come into it on autopilot, you may overlook those things. So I would encourage counsel to not simply march in with their, this is what I do on procedural order number one, please sign, because I think you're going to overlook things that you would have caught if you had a bit of a more a la carte approach.
I agree with that, with what Angus has said, and I would add that you should also let the parties know that procedural conferences will be ongoing. as may be required, and perhaps on a preordained schedule, because given the pace of an arbitration being a lot faster than the court process, there will be developments that need some guidance. And I always invite parties to come back to revisit the procedural directions and see whether additional directions might help the parties to get the matter to hearing in a fully prepared fashion. And those are effective. But in that context, I've also found that the parties, if they're working collaboratively, can and often do prepare consent orders for next steps that really couldn't be set down in a term of an order at the first conference. And I agree with Angus that you, as an arbitrator, shouldn't just accept those, and you should reflect on them and make sure that they suit the process that you envisage. And if there is something to be discussed further, you can let the parties know and have them get back to you in writing or by way of a resumed procedural conference. The electronic means of communicating with parties is simply excellent in terms of keeping everyone involved and the preparation for the hearing ongoing.
Well, and Murray, you raise a good point. I mean, there's the on the one end of the spectrum, the ill-prepared parties who treat initial procedural conference as an initial get to know you. Then there's the other end of the spectrum where the parties come before the arbitrator with a pre-agreed procedural order, which may contain things that the arbitrator thinks are not appropriate, counterproductive, or inefficient. Angus, what do you do in that? What do you do in that situation when you're presented with an agreement reached by the parties before you, which you as arbitrator have reservations about? Murray has given some ideas, but as a practical matter, what, if anything, can an arbitrator do?
Well, ultimately, arbitration is a consensual process, and if the parties decide that that's how they want to run the show, then as arbitrator, I consider myself bound by that, as long as it's in compliance with the rules in the Act. What I would do, if I think the parties are making a mistake, I'll tell them that, and I'll say, look, I know you've agreed to item 7 here. Can we just talk that through and you know, have you considered this possibility, and just sort of expose them to why I have reservations about that and see if it influences their thinking. It's always the case that a procedural order is subject to revisitation. That's a standard term in my procedural orders, and it may be the parties think again about the process. And so if it isn't solved in that initial meeting, it might be solved in a future one of the kind that Murray described.
Great, thanks to both Murray and Angus for that useful overview of the first procedural conference. We've coming to the end of our time, and I see Laura on the screen, so I will pass it back to Laura.
Thank you all. That was excellent. We've been quite efficient actually in answering many of the questions as we go here. So we don't have a ton, but I'll just give people a minute if you want to type a question into the chat or Q&A, we'll try and answer it. And those of you that have to sign off can. Next week, we have the continuation of our program with a focus on advocacy. So we're going to talk about the mechanics of the hearing, witness statements, all the things that go into the actual arbitration hearing and beforehand. And we'll also be talking about what happens after the hearing. So we'll get a little bit more into some of the appeals and set aside applications that we've touched on today, as well as enforcement. Henry, if you're still on, I received a question about whether you found the 20 binders of evidence delivered with that notice of arbitration that you mentioned to be helpful or a good strategy. What was your response to receiving that?
Well, as anybody, I think I was a bit overwhelmed by it. It did give me a good sense, though, in advance of the procedural conference of what we would need to deal with. I recognized, and I think the other side recognized, that it was an attempt to put as much pressure on them as possible, which of course we built in ample time for a response to the request for arbitration. Under the particular rules, there is an opportunity for a response. So it was a bit overwhelming, but what I did find is that there were a number of documents that were important and were useful to know about up front. This was a merger and acquisition case with fraud allegations attached. So it was helpful, although overwhelming. I had to find space to store 200 binders of documents, which this was back in the days where not much was done virtually or electronically.
Great, thank you. So I've got another question for any of our panelists about circumscribing the rights of appeal in your arbitration clause, because we do have the ability to do that under our domestic act now. Any tips about how you should do that clearly? Is there anyone, any of the panelists in particular that want to answer that? I see Joe's come on the screen.
I'm happy to take a crack at that, and
Sure.
others will have different views, perhaps. My own view is, especially now in British Columbia under the new Domestic Act, because you have the right to say there will be no appeals, my recommendation is to take that right. And I look, if you're starting without knowing what the dispute is and anything, my own view and my own recommendation to clients is you really get your dispute resolved. You might not be happy with the result, you may be, but you won't be happy if you're going to appeal to court and then spend 2 or 3 years fighting about that arbitration award through the court process. The new act has kind of, hopefully, at least on the appeal side of things, has made it hopefully a quicker process, because you appeal directly now with leave to appeal to the Court of Appeal. So it takes away one step of the process, but it's still, I don't think you end up necessarily, the parties end up with a better result just because you've gone from an arbitrator to a court to review an issue. And I think it ends up a lot of resources have been spent that I don't think you necessarily get a better result necessarily. And certainly maybe it's unbiased because my experience is I'm much more successful in arbitration than I am in court. So maybe that's where it comes from. But I would recommend just saying no appeal. And it's not clear whether under our current act, I don't think you have the ability to give the Court of Appeal authority to appeal on a question of fact. It's only a question of law. Under the optional VanIAC arbitration rules, arbitration appeal rules, you could do that if you wanted to. That's one of the options. But my general view is I wouldn't do that. If you're really concerned about the scope and the importance of it, then make sure you have a 3-person arbitration tribunal. But that's my view.
Laura, just to add in, I totally agree with what Joseph said, and to draw a little line between the common law jurisdictions in Quebec. In Quebec, there is no appeal. Even if you put it in your agreement, there is no appeal to the court on anything that you consider useful or desirable once you've lost. So the point of arbitration is to do it once, do it well, do it properly, and do exactly what the last panel talked about, is take it seriously right from the first case management conference. And the case law in Canada now is asking the parties to be very clear about the fact that there is no appeal. So it's not just sufficient to say, well, it's final and binding. Some of the judges and unsatisfied parties are quite creative in convincing the court, well, maybe the silence meant there's still an opening.
Laura, can you hear me? It's Jonathan Eads.
Yes. Hi, Jonathan.
Sorry. Hi. My video is not working for some reason. I agree with everything that's being said. I would say in the British Columbia context, read section 59 of the Act. My videos come back. I would read section 59 very, very carefully, because there is express wording. This in government, I advise that you do not want an appeal. track the language. I don't have it in front of me right now, but it's just extract from the statute, put that in. Then you would avoid what Dan has raised, this issue, these arguments. Well, we said it was final and binding, therefore we didn't want an appeal. I wouldn't rely on that at all. I would really track the statute in British Columbia.
Thanks, Jonathan. We have a question about choosing a technical expert as an arbitrator rather than counsel, which does happen. There are arbitrators that are not trained as lawyers. And sometimes where this is works particularly well is where you have a panel of 3 and one of the individuals is more technical, but there are many arbitrators that are not trained as lawyers as well. Does anyone want to share views on sort of the pros and cons of having a technical expert as opposed to legal counsel? I think the answer probably generally is it depends on the dispute, but appreciate other views. Tracy?
I think as counsel, my view is that it's a very rare occasion where I would want, particularly if you don't have a panel of 3, but that you would want a technical expert. And I think if you listen to the wisdom of the last panel, which is the first procedural conference and all of the process that has to go into that and thought that has to go into that. My experience is if you have someone who's not a lawyer running that process, it just doesn't run as smoothly. And it's very difficult for them in circumstances where inevitably issues arise at the hearing that relate to matters like hearsay or other points of law that come up inevitably in a hearing, and they just don't have the depth of experience to be able to deal with it. So I would be very reluctant to agree to a technical expert as a sole arbitrator. And I'd never seen it in a panel context, and I would welcome the comments of arbitrators who've had to maneuver or deal with that process.
Laura, it's Murray.
Yes, hi, Murray.
I was once retained by an arbitrator who was not a lawyer. The context was a dispute between members of a particular faith, which has a, just a second, I'm going to start my video, which has a traditional and well-established dispute resolution process by members of the community who are considered to be wise men. The dispute was commercial in nature and a very technical tax component. And so the parties agreed to appoint a tax expert to give advice to the arbitrator and a lawyer to give advice to the arbitrator in terms of process. And it worked out very well. It achieved the dispute resolution within the context intended by the community environment. But it also, I think, resulted in a effective and enforceable award that was able to be implemented as was the goal of the ultimate, of the submission to arbitration within the community. And so, I think it's good, but if you're designing something like that or advising on something like that, remember that there are real risks with respect to enforcement if the arbitrator is not well-versed in making sure that all of the necessary protections are made available to produce an enforceable award.
I'll just jump in here, Laura, to agree with what Tracy and Murray have said, and just to add one other point, which is one peril of appointing a subject matter expert as neutral is it imposes a real burden on the arbitrator in that situation to partition his or her mind. The arbitration is meant to be decided on the evidence, on the record, and there are cases that have been litigated over allegations that the subject matter expert serving as neutral ended up drawing upon knowledge that he or she had by virtue of that expertise and not material that was adduced in the arbitration. So it's not impossible, and certainly there are advantages to having subject matter experts, but you do run the risk of potential debates over whether the arbitrator expert has properly navigated that line between one's own knowledge and whatever the record is in the proceeding.
Or it's Rob, can I just make a point there? I mean, I've had a non-lawyer expert as arbitrator in one case, and it went fine. It went perfectly fine. I think one of the values of arbitration is that you have the ability to appoint a non-lawyer, someone who doesn't think like you as your decision maker. And I think, you know, I agree with everything that's been said, but I have to tell myself that the pool of arbitrators we keep going back to is not that deep. And I think we should stop and think about, you know, why are we using that same procedural order for this case? Well, why are we using the same pool of arbitrators for every case? And I think there's benefit to, it's scarier because you don't know the person perhaps as well, and you don't share perhaps a particular outlook. But that potential for diversity is what sets arbitration apart. And so I think we do need to be careful in appropriate cases to lift our sights and think outside the box.
I would just add to what Rob is saying on that, and also give a shout out to one of the supporters of this mini course is the Chartered Institute of Canada, Chartered Institute of Arbitrators, Canada branch, and the Chartered Institute does welcome non-lawyer members in, and part of it is the training that those people get. So non-lawyer arbitrators can get the training to do some of the arbitration. So I agree with Rob. I think we have to be careful here about dismissing non-lawyer arbitrators in terms of their ability to run a well-run enforceable arbitration. It might be a little bit different, but provided they have the sufficient training, I think it's in the right case. I think there's nothing to stop you from doing that. You shouldn't hesitate.
Laura, if I can jump in, I agree with just about everything that's been said. One of the difficulties in appointing a non-lawyer expert, particularly as a sole arbitrator, but even to a tribunal, is the perception from counsel for the parties that either they will not be sufficiently well versed in procedure, but perhaps, and going to Angus's point, that there is a concern that the expert will not be able to disassociate his or her personal views. And there are many technical issues where experts become aligned with a particular view. They see, you know, questions of metal fatigue or concrete consistency in a particular way, and then the parties get very worried about that and whether the arbitrator will be able to disassociate themselves from that. So that's perhaps one of the bars to more appointments. And the second one is conflicts. Conflicts of interest for an expert will be different than conflicts of interest for an arbitrator. So you're going to have some hurdles to have that happen. That said, I'm with Rob Dean. There are non-lawyer experts in fields that are well-versed in arbitral procedure and who do function frequently as arbitrators. I think of complex areas like certain aspects of construction law and scheduling. And in cases like that, you can save a tremendous amount of time. The problem is you have to have sufficient confidence in the arbitrator. The other solution, of course, is for the tribunal itself to retain the technical expert with the consent of the parties in exceptional cases, which I've also had an opportunity to do, and it worked out fine, and the tribunal was greatly assisted. So it's party autonomy. You want to agree with everyone involved and see how you can best work it out.
Just very quickly, Laura, to elaborate on what Angus Gunn was talking about, is one of the tensions in arbitration is when you're choosing someone with subject matter expertise, it's a very fine line, and it's held by the arbitrator. He or she might know so much about an area that they're effectively, in poor cases, going to decide the matter within their own head without the benefit of having counsel who agreed to them to serve as an independent and impartial arbitrator, without the opportunity for counsel to either hear what the argument is inside that person's head or the evidence that they're considering. So subject matter can tip into I know better or I know best. And that's where you have to be very alert to that. And it's not technical experts who are prone to that. It can be lawyers also very easily.
Good points. One thing I would just conclude with is to keep in mind that sometimes parties will have in their agreements that there's a particular issue that an expert will determine for them, like a particular accounting issue. That is something different from arbitration. So sometimes parties think that they're entering into an arbitration when it's really just having a particular issue determined by an expert. It's just something to be aware of. I think that covers all of the questions we've had today. So we will conclude, and we hope to see you all again next week. Thank you all for participating, and thank you to all of our panelists for your excellent presentations.